is Guy Charles. I am the Charles Ogletree Jr. Professor of Law. It is my distinctive pleasure to introduce the Francis Biddle Memorial Lecture and to welcome Professor Cristina Rodriguez, who will present the lecture entitled Equality, Polity, and Immigration. We couldn't be more pleased to have her with us this afternoon. She is as distinguished as an academic as there is in our profession, and we're so delighted to have her here, and I know that we'll all learn from her. Before introducing her, as well as saying a few words about the lecture, I want to acknowledge our Dean, Dean John Goldberg, and also to thank him publicly for taking on this important role, and we're so pleased to have his leadership. So to acknowledge and welcome his presence as well, but to also to acknowledge and to thank him. Thank you, Dean Goldberg. Francis Biddle graduated from Harvard Law School in 1911. He was a law clerk to Justice Holmes. He went on to serve as Attorney General during World War II and as a U.S. member of the International Military Tribunal at Nuremberg. The Biddle Lectures arose out of a gift from his widow, Catherine Biddle, who asked that the selection of our lecturers reflect, and I quote, that civil liberties and civil rights were of particular concern to my husband and thus particularly appropriate subject areas for the lectures. I can think of no one better who fits that description than our speaker today, Professor Cristina M. Rodriguez, the Leighton Homer Surbeck Professor of Law at Yale Law School. She joined the Yale Law faculty in 2013 after serving 2 years as Deputy Assistant Attorney General in the Office of Legal Counsel at the U.S. Department of Justice. She was a professor at NYU Law School from 2004 to 2012. And in 2021, she was appointed by President Biden to co-chair the Commission on the Supreme Court of the United States, which she did, not surprisingly, superbly. Her fields of research and teaching include constitutional law, constitutional theory, immigration law and policy, administrative law, process, and citizenship. Her recent writings have included the foreword of the Harvard Law Review, Regime Change, and the recent book, The President and Immigration, co-authored with Adam Cox and published by Oxford University Press. She is the author of 2 important case books, one on immigration and refugee law and policy, and one on racial justice and the law, and candor compels me to say that I'm also a co-author of that case book, but she is the star of the case book. In recent years, her work has focused on the relationship between administrative and executive governance in democratic politics and decision-making. She has turned to immigration law and related areas as vehicles through which to explore how the allocation and exercise of power through federalism, separation of powers, the structure of bureaucracy shapes the management and resolution of legal and political conflict. Her work has also examined the effects of immigration on society and culture, as well as the legal and political strategies societies adopt to absorb immigrant populations. She's a member of the American Academy of Arts and Sciences and the American Law Institute. She's a trustee and non-resident fellow of the Immigration Policy Institute in Washington, D.C., and past member of the Council of Foreign Relations. She earned her BA and JD from Yale University and Yale Law School, and she was a Rhodes Scholar at Oxford University. Following law school, she clerked for Judge David Tittel of the United States Court of Appeals for the D.C. Circuit and Justice Sandra Day O'Connor of the United States Supreme Court. It is my distinctive pleasure to present to you our lecturer, Professor Cristina Rodriguez.
Thank you for that introduction. I think this is now on. Thank you for that introduction, for the invitation to be here, and to all of you for coming this afternoon. Across the 21st century, the growth of the international migrant population has outpaced overall population growth. An estimated 284 million people today are international migrants, more than 130 million of them forcibly displaced or stateless tumultuous as the result of uniquely high levels of global turbulence. Most of this movement is the result of violent conflict, but it also has arisen because of weather-related events arguably fueled by climate change, a number the World Bank predicts will increase to 216 million by 2050. As a total percentage of the global population, 3.6%, these numbers are small, but the phenomenon is roiling domestic politics the world over. Debates over how to manage mass migration have become increasingly intertwined with how to preserve, shore up, and even renew the welfare state, and reverse gross inequalities within wealthy societies. Inequalities that themselves have become a central academic and political preoccupation. Irregular migration and refugee movements have been exploited by authoritarian populists to build political support and win elections. Even as rapidly aging populations, declining fertility, and persistent labor shortages in developed nations temper the power of political forces urging more restrictive policies, the countries of the so-called global north have dedicated record-high resources to their border enforcement in recent years. Deeply rooted historical assumptions that migrants displace host citizens in job markets, fail to engage with local communities, produce crime, and disproportionately rely on state assistance persist the world over. It matters less whether these assumptions are true, mostly they are not, than that they are semi-fixed heuristics that host societies and their politicians rely on. Considerable social science research supports the hypothesis that perceptions of one's own group's economic conditions strongly predict attitudes toward immigration, whether substantiated or not. In other words, the meaning of immigration is a political question. Here in the United States, over the course of my almost 20 years studying the subject, the core policy problems have remained strikingly constant, but the politics have followed a bewildering path. Immigration has gone from a cross-cutting issue that found supporters and detractors in both political parties in the late 20th century and early 2000s, to a nearly perfectly sorted issue by the mid-2010s, with Democratic lawmakers on the side of immigrant rights and comprehensive expansionistic reform, and Republican lawmakers favoring enforcement and restriction, culminating in the election of Donald Trump in 2016, and the advent of an administration with a truly thoroughgoing commitment to shutting down as much immigration as possible. To our present moment, when it seems possible that the center has fallen out of the debate altogether, and with a Democratic president who began with idealistic promises of renewal, but now seeks credit for doubling down on enforcement in order to stem the political problems that pressures on the border clearly have created for him. Deploying the rhetoric of closing the border has become a political imperative, despite the fact that no such policy is actually possible. Whether the United States has control over its sovereignty and demographic future seems likely to be a central issue of the 2024 presidential campaign. Today, I will focus not on making predictions, setting factual records straight, or unschooling strategic advice. Instead, I'd like to take the opportunity of this lecture and this political moment to understand and conceptualize the place of immigration and immigrants in our political discourse and the life of the nation. Today's politics on the issue ultimately involve conflict over three separate accounts, each of which has a relationship to influential strains of modern political theory, as well as historical roots and legal and sociological manifestations. Crucially, these accounts or paradigms are not necessarily mutually exclusive, but they understand the relationship of immigration to the polity in distinct ways, and of special interest to me, accord distinct forms of priority to the rights and interests of immigrants themselves. These conceptions reflect overlapping ways in which Americans have been constituted as a people. Understanding this process of composition is important because, as Roger Smith puts it in his Stories of Peoplehood, human beings have never successfully pursued any of their many aspirations and endeavors. They have never sustained stable families, built prosperous economies, formed organizations for spiritual fulfillment, constructed great buildings and monuments, created enduring works of art, made great scientific and philosophical achievements, without being organized into particular peoples. The actual process of composition, I would add, never stops, producing ongoing political struggle and even conflict. And the immigration debate is one of the composition's key features. In brief, I enumerate these interlaced accounts as the self-government paradigm, the civil rights paradigm, and the global or networked paradigm. My intention in this lecture is to lay out their key elements, not because doing so will clarify the immigration debate, but because it will underscore the unstable amalgam that is American immigration law and policy, as well as the recursive nature of political debate over this constant challenge. I pay special attention to the particular ways in which conceptions of equality, both political and economic, help shape each paradigm, because the rhetoric and theory attached to each paradigm depend heavily on this underdefined value. This effort to articulate frameworks that are much easier to state than to realize should help clarify the trade-offs and consequences associated with trying to shape law or policy around any one of them, ultimately underscoring that pragmatism inflected by principle may be the only way through. So the first paradigm of self-government. The self-government paradigm relates to a recurring strain of political theory that connects immigration restriction to democratic flourishing and social welfare. Michael Walzer famously offered an argument grounded in distributive justice for immigration control as a prerogative, perhaps even obligation, of the nation-state. He begins from the premise that the idea of distributive justice presupposes a bounded world, that that world is the political community, and that the primary good members of the community distribute to one another is membership within it. For a democratic society to be open within, he reasons, it must be closed from without. To tear down the walls of the state is not to create a world without walls, but rather to create 1,000 penny fortresses. A new generation of theorists similarly has sought to ground moral justifications for immigration control in concepts of self-government. Emblematic of this line of thought is the work of Sarah Song, who argues that immigration restrictions can be justified as acts of collective self-determination, even as humanitarian and democratic values may constrain the way a government's immigration power may be exercised. It is permissible, in her view, to give priority to our fellow compatriots, because and to the extent that we are engaged in what she calls a scheme of social and economic cooperation through participatory institutions. The concept of self-government need not lead to restrictionism. One common justification for expanding immigration, rooted in its long-standing link to economic growth writ large, is that declining fertility rates among U.S. people, coupled with the need to support an aging society and sustain its dynamism, will necessarily require high levels of immigration. But much more interesting to me, and more in the vein of this particular tradition of political theory, are the claims in favor of restriction that prioritize the interests of existing citizens and that have filtered into mainstream, centrist, and left-leaning discourse, where claims about the benefits of free trade, open immigration, and concomitant economic growth, until very recently, were conventional wisdom. Representative to me of this development is the intervention by a New York Times economics reporter, David Leonhardt, who in a book devoted to how to restore the American dream of upward mobility, contends that immigration has become a blind spot of the left. The way forward, he implies, may entail greater restrictions. He recasts the landmark immigration reforms of 1965, often regarded as part of the nation's second Reconstruction, more on that in a moment, as a foundation of the neoliberal order that has created the economic mobility crisis, dating neoliberalism's origins to long before the Reagan coalition ascended in a set of reforms to the immigration code whose consequences congressional Democrats and President Lyndon Johnson failed to predict. His argument, like the claims of other critical of the relationship between immigration on the one hand and democracy and equality on the other, has two key empirical or sociological features. The first is economic. Contested hotly and for a long time among economists themselves, the claim that large-scale immigration of lower-wage workers has depressed the wages of American workers. According to this line of research, the economic growth accelerated by immigration has benefited high earners and native professionals, but come at the expense of the working class, much like free trade. These claims are often linked to research by Claudia Golden and others documenting how the national origins quotas of the 1920s, which severely restricted immigration to the US, led to increased wages for workers, including black workers. Findings giving moral weight by the critiques that coincided with the last wave of mass migration to the United States between 1880 and 1920. The critiques of Booker T. Washington and Frederick Douglass, who both lamented the displacement of blacks by immigrant workers. Claims that racial and economic equality might require immigration restriction, including in the form of tougher enforcement, also animated the report and testimony given by Congresswoman Barbara Jordan, whom President Clinton tapped to lead a commission created by the 1990 Immigration Act on immigration reform after her retirement from the House. She said, immigration is not a right, guaranteed by the US Constitution to everyone anywhere in the world who thinks they want to come to the United States, she argued. It is a privilege granted by the people of the United States to those we choose to admit. In response to the rise of illegal immigration that dominated the debate in that era, much like it does today, she contended that any sovereign nation worth its salt must be able to control its borders. What we are dealing with is nothing less than the definition of America. Her commission recommended reducing annual immigration by the hundreds of thousands and enforcing the employer sanctions regime that had just been enacted in 1986 with vigor. They recommended faster reunion of nuclear family, but found, quote, no national interest in continuing to import lesser skilled and unskilled workers to compete with the most vulnerable parts of our labor force. These recommendations did not come to pass, both because of the business interests arrayed in favor of immigration and because civil rights lobbies worried about the discrimination and harassment they thought would arise from these reforms, especially renewed enforcement for Asian and especially Latino workers. President Clinton instead signed a bill in 1996 that dramatically expanded the nation's deportation machine, its legal and logistical capacity to enforce ex post limits on legal immigration. The truth of this underlying economic claim remains contested. And to the extent depressive effects on the wages of US workers with only a high school education or less can be documented, studies showing them suggest they are relatively small. Evidence also suggests that immigrant workers have largely been complements, not substitutes, for low-wage US workers. But even granting modest wage depression, we might still be wary of the claims because of the very real possibility that immigration becomes a red herring that distracts politicians from far more complex and higher stakes bases for wealth inequality. The political explanation for the self-government paradigm must therefore be confronted. The need for immigration control is defined and defended both as a means of producing the solidarity and fellow feeling required to ensure a robust democracy, and as a response to the exploitation of nativistic and even racist fears by demagogues. In other words, a call to reduce their source material. As political theorist David Miller puts it, with national identity comes a kind of solidarity that is lacking if one looks just at economic and political relationships. People feel emotionally attached to one another because they share this identity. This nationalist view says we have special obligations to compatriots because they are one of us, an extended kin network. A great deal of sociological work of the last 20 years provides some support for this by underscoring the sense of cultural displacement and political alienation immigration can create amongst a native population. Empirical support for the logic of 1,000 penny fortresses. Some of this work is based on conceptions of race prejudice in the United States South that identifies conditions under which an in-group that considers itself to be superior will feel threatened and therefore seek to exclude an out-group perceived as different and with whom they interact in daily life. Scholarly literature also consistently identifies symbolic cultural concerns as significant drivers of anti-immigrant sentiments and underscores how media environments and political rhetoric play pivotal roles in perpetuating this sense of threat, thus influencing public opinion and behavior. Indeed, media and demagogic politicians might even heighten and manipulate perceptions of threat to sell people policies that actually undermine their material interests, a central argument made by political scientists such as Jacob Hacker and Paul Pierson about today's Republican Party. Proponents of the self-government model, as I have styled it, are careful to distance themselves, of course, from nationalistic understandings of social solidarity. And theorists like Song accompany their basic defense of restriction with limits on that authority derived from universalistic world principles. Proponents of self-government and its dystopian distortions also produce distinct policy prescriptions. Jordan declared herself resolutely pro-immigrant, and the likes of Leonhardt call for minor immigration cutbacks or reorientations of existing policy, combining robust refugee resettlement with a focus on high-value economic targets, less tolerance for illegal immigration, less family migration. But Stephen Miller and his ilk seek all of that and much, much more, up to and including an end to birthright citizenship for people who don't have at least one US citizen parent. But whatever its manifestation, the priority under this model belongs to the extant political community and the interests of its existing members. The second paradigm, the civil rights paradigm, what do I mean by this? As scholars have remarked, the temporal coincidence, as well as the discursive linkage of the immigration reform of 1965 with the Civil Rights Act of 1964 and the Voting Rights Act of 1965 is too obvious to be missed. By the time of the 1965 Act's passage, the linkage between civil rights and elimination of race-based exclusions and national origin quotas in the immigration laws had become a familiar rhetorical device of Democratic politicians. In a 1948 message to Congress, Harry Truman called on Congress to end race-based restrictions on naturalization. He vetoed the 1952 Immigration and Nationality Act, despite his belief that it improved the system as a whole, because it maintained racially discriminatory quotas. President Lyndon Johnson exhorted Congress in his 1964 State of the Union to, quote, return the United States to an immigration policy which both serves the national interest and continues our traditional ideals. He observed that no move could more effectively reaffirm our fundamental belief that a man is to be judged and judged exclusively on his worth as a human being. And Vice President Hubert Humphrey even more concretely noted that we want to bring our immigration law into line with the spirit of the Civil Rights Act of 1964. Some commentators emphasize statements made by Ted Kennedy, a prominent senator at the time pushing this reform, a key proponent of the bill, and other Democratic lawmakers in response to Republican skeptics, in which these supporters of the law emphasized that changes to the quota system would not actually fundamentally reshape the demographics of the nation. These statements sought to reassure the skeptics that the reforms were not radical reimaginations of America's white Protestant identity. A somewhat different critical perspective emphasizes that though Truman, JFK, and LBJ all tied the end of the immigration quotas to the broader civil rights objectives of equal treatment without regard to race, they did so mainly to promote the idea of American virtue by aligning the formal legal system with the nation's developing self-conception as incompatible with racially defined citizenship. These reforms were process-oriented and did not actually occasion a particularly broad or popular debate about how American society ought to use its exclusion powers to constitute the people, or treat non-citizens with claims to belonging who might not conform to the law's ordered immigration trajectory. There was little to no social mobilization behind the immigration reforms either. They were largely the product of interest group politics, Italian and Jewish lobbies, and pressure from the State Department to abandon a policy that was hurting U.S. relations with parts of Europe and increasingly important allies in Asia. Revisionist scholars, on the other hand, emphasize that members of Congress knew the changes in the law would result in an influx of Asian immigrants in particular, that lawmakers knew and embraced the fact that it would be changing the face of the country in service of a non-discrimination ideal. Historical debate continues about just how revolutionary and non-discriminatory the law's authors thought they were being. In this vein, it does bear noting that across the wealthy immigrant-receiving world after 1960, conceptions of the liberal state replaced the national state through diminishing ethnicity-based selections. As Christian Yapka has put it, although it is notionally the foremost expression of the state's sovereignty, immigration as well as citizenship policy is no longer at the service of reproducing historically particularistic nationhood, at least for now. And regardless of lawmakers' expectation in 1965, it seems fair to say that the politics, as well as the achievements of the civil rights movement, helped make the trajectory of immigrant reception and incorporation more open and stable. By clearing the path of formal racial and ethnic barriers, the 1965 Act transformed the concept of the people into a body composed without regard to ancestry or race, a meaningful civil rights advancement that can be better appreciated now that the leader of one of our major political parties traffics in and seems to gain support because of a fascistic understanding of immigration's threat to the blood of the American people. A perhaps more important version, however, of the civil rights paradigm links immigrant communities to the movement struggle of the era. Throughout the mid to late 20th century, there was a granular reality to the interrelationship between civil rights and immigrant rights. Most prominently, the advocacy of Cesar Chavez, Dolores Huerta, and the United Farm Workers involved the intertwined interests of long-resident Mexican Americans and newly arrived immigrant workers. It is true that labor advocacy helped bring an end to the post-World War II Bracero guest worker program, curtailing legal immigration to serve the interests of the already present. But these movements also helped cement a solidaristic relationship between immigrant and non-immigrant workers, which in turn formed part of advocacy efforts to develop legal services for the rural poor and remains critical to labor organizing today. Today, the major Latino civil rights organizations, the Mexican American Legal Defense and Education Fund, and Latino Justice PearlDef, once upon a time known as the Puerto Rican Legal Defense and Education Fund, focused on a marginalized but decidedly not immigrant in origin group, are now largely immigrant rights organizations. In litigation and public commentary, these advocates target as modern-day instantiations of Jim Crow the state and local laws that began mushrooming across the United States in 2005 and are today flashpoints of partisan federalism. See the work of Governor Greg Abbott. The majority of which seek to make life difficult for unauthorized immigrants or wield state authority to enforce immigration laws where the federal government cannot or will not. Both federal and local immigration enforcement are decried for the civil rights externalities they generate, rights violations that fall disproportionately on lawful permanent residents and U.S. citizens of the same race or national origin as the primary targets of law enforcement, namely Latinos and Mexican Americans. Calls to support the DREAM Act and to preserve DACA often reflect an effort to tap into this historical struggle for justice and inclusion by marginalized groups embodied in the civil rights movement. This civil rights claim is more than an argument against labor exploitation or perceived legal abuses. It's a claim for incorporation of immigrant subjects and a claim that justice demands it. These claims underline how the formation of the people can outpace legal formalities by taking shape through quotidian social interactions, sociological and ethical realities that eventually necessitate a legal foundation. Consistent with its universalistic underpinnings, the late 20th century civil rights paradigm also took shape through an admittedly ambivalent constitutional jurisprudence. In Graham v. Richardson in 1971, for example, the court applied Caroline product-style analysis to the status of non-citizens and concluded that the 14th Amendment's Equal Protection Clause required heightened scrutiny of citizenship classifications. The 14th Amendment also became a bulwark against ideological or other grounds for expatriation. In Plyler v. Doe, Justice Brennan advanced an anti-caste understanding of the Equal Protection Clause that emphasized sociological over legal membership. In striking down a Texas law that would have prevented unauthorized immigrant kids from attending public schools, he mixed a commitment to an anti-subordination vision of equality with recognition of the social ills that would result, emphasizing, quote, "The denial of education to some isolated group of children poses an affront to one of the goals of the Equal Protection Clause, the abolition of government barriers presenting unreasonable obstacles on the basis of individual merit. The inestimable toll of that deprivation on the social, economic, intellectual, and psychological well-being of the individual makes it most difficult to reconcile the cost of the principle of a status-based denial of basic education with the framework embodied in the Equal Protection Clause. We cannot ignore the significant social costs borne by our nation when select groups are denied the means to absorb the values and skills upon which our social order rests." Though the court has never applied the same heightened equal protection scrutiny to the federal government's alienage classifications, the due process revolution of the same era effectively transformed the non-citizen's interest in remaining in the United States into a liberty interest supported by procedural guarantees. Proponents of the self-government paradigm sometimes seek to reconcile it with the civil rights paradigm, much in the way Barbara Jordan did, by separating the way we treat immigrants in our midst with the immigration policy we adopt to let them in. The former we should regard, in Hiroshi Motomura's evocative formulation, as Americans in waiting, even as we enforce the limits we set on immigration in the name of sovereignty and democracy. But as immigration scholars have emphasized in their critique of the court's efforts to do the same, to draw the same distinction, conceptually and practically, the two are not so easy to separate. For one thing, exclusion necessitates interior enforcement within our midst in ways that produce the very civil rights externalities that I had just invoked. More fundamentally, illegal immigration, a defining feature of the immigration system for more than 40 years, underscores that we must either accept limits to the self-government paradigm or accept that it must come with draconian treatment in order to enforce the control at the heart of it. Conceptually, if we regard immigration restriction as legitimate, even as democratically necessary, then the self-government paradigm has to accommodate ambivalence about immigrants' rights, and ambivalence clearly reflected in our law as well as politics. As Linda Bosniak has observed, the unauthorized immigrant in particular has long had a dual identity in American consciousness as both an outsider to and a member of the national community. If we acknowledge the unauthorized immigrants' membership claims, as the civil rights paradigm suggests that we should, then we also have to accept their rebuke to the conventional account of how we give shape to the people. Put slightly differently, unauthorized immigration is at least in part a consequence of the choice to exclude. For instance, the end of the Bracero guest worker program did not end labor migration, but rather forced it outside of the law. This means that the self-government paradigm can and has given rise to what we might otherwise describe as civil rights crises, the persistence across decades of a population that lives in the proverbial shadows. The phenomenon of illegal immigration ultimately brings us to the third paradigm, what I will call the global or network paradigm, according to which the inequality produced within the United States illegally and the inequality across borders that illegality represents amounts to a form of injustice. If we expand our perspective on equality from the domestic political community to the wider world, disparities across nations become glaring. The global inequality began to really rise in the 18th century with the Industrial Revolution and what historians call the Great Divergence between Europe and North America on the one hand, and Asia and the Middle East on the other. It reached its historical high point in the late 20th century, possibly as late as 2000. As historian Darren McMahon explains, the great compression in the wealthy world, the dramatic reduction in inequality within wealthy nations during the advent of the post-war welfare state, was experienced in the global south as the Great Squeeze. In his words, quote, "The welfare state compounded the West's myopia, encouraging its citizens to see their egalitarian commitments and horizons largely in national terms, regarding equality at home and abroad as on separate tracks." Martin Luther King certainly regarded the US civil rights struggle as bound up in world struggle. He said, "Equality with whites in the United States, aspirationally toward the end of his shortened life, will not solve our problems if it means equality in a world society stricken by poverty and in a universe doomed to extinction by war." Post-colonial critics such as Frantz Fanon and Aimé Césaire pointed to this inequality across nations to reveal the hypocrisy of post-war human rights speeches declaring the equal worth of all human beings. What should we make of the fact that just as wealth inequality began to grow again in the West in the 1980s, growing inequalities of wealth and income between the world's peoples began to level off and fall? And what does migration have to do with this? Debate over whether this evolution in relative equality across nations was causal or coincidental continues. Could it have related in some way to the mass migration and freer trade of the last 40 years? It certainly has something to do with the emergence from poverty of millions of people in China and other parts of Asia. But whatever these empirics, these dynamics do suggest that an egalitarian political theory ought to be attuned not just to inequalities within states, but across them. The global paradigm resists what historians might tell us has always been true, that inequality always belongs to equality. To put this idea in terms of borders, Joseph Cairns famously argued that citizenship is the modern equivalent of feudal privilege, an inherited status that greatly enhances one's life chances. Whether we are born in a poor or a wealthy country, and our concomitant citizenship are matters of pure luck. Borders and their enforcement entrench this inequality. Fulfilling liberal egalitarian commitments requires more than ensuring equality of opportunity for fellow compatriots. Open borders, he argues, are required to respect the equal moral worth of all human beings. A conclusion he and others reinforce with empirical observations, such as the fact that migrants from countries low on the Human Development Index see a 15-fold increase in incomes and a doubling in education rates when they move to higher HDI countries. Other scholars have begun from the same premises, but do not advocate open borders as a consequence. In the words of Ayelet Shahar, citizenship, and by implication borders, quote, distributes voice and opportunity in a vastly unequal manner. Within this larger global justice literature that expands the scope of obligation beyond fellow citizens to all of humanity, scholars like Shahar call instead for other forms of global redistribution. Sarah Song emphasizes that immigration exclusions should also be accompanied by robust development assistance from wealthy countries to poorer countries. Charles Bites identifies a progressive internationalist offspring of his morality of states in what he calls social liberalism, which combines a state's priority for domestic compatriots with its obligation to an international community responsible for assisting states that cannot satisfy the human rights and basic needs of its people through development aid and disaster relief. This approach, which also finds support in the worlds of immigration policy and development economics, builds in clear obligations sounding injustice on the part of wealthy states and peoples to poorer ones and their peoples. It also bears some similarity with Rawls's observation in the law of peoples that the causes of immigration will disappear in the society of liberal and decent peoples with the achievement of a realistic utopia. These sorts of responses, however, are too easy because they are fanciful. They ignore the fact that for many individuals in the here and now, migration provides the response to this inequality, as evidenced by people on the move. According to one IOM simulation, if barriers to migration were eliminated, half the population of non-OECD countries would emigrate. Estimations of Gallup surveys show that 14% of the world's population would migrate if they could. Indeed, migration has come to be understood by sociologists and economists as part of development. This conclusion is reinforced by recent research in validating claims of big brain drain through migration, supporting instead immigration's link to enhanced investment in education in sending countries and the return to countries of origin of better resourced immigrants. A critical feature of these migration dynamics, for my purposes, is that they are networked. They follow patterns that replicate old colonial relationships and that track shifting borders, foreign policy entanglements, and diasporas born from these dynamics. A way to put these dynamics in the language of obligation that is more specific than the global justice literature and arguably therefore more helpful comes from scholars like Roger Smith. He has argued that the United States bears an obligation to those on whom the country has imposed itself and its interests. In other words, the sphere of the nation's obligations is not just to its particular members, but to its wider sphere of influence, including the people whose unequal status and subsequent movements it might have helped create. That is certainly one way of reframing so-called illegal immigration. The illegality actually represents a sleight of hand that attempts to disappear the nation's complicity in the migration's creation. To be specific, and one particular way of consequence about the effects of the law, embedded in the regime created by the Immigration Act of 1965 was a legal scheme that has helped actually give rise to illegal immigration, which has made our immigration politics so charged for decades. The major innovation of 1965 was to eliminate country-based quotas and to apply the same numerical limits to all countries of the Eastern Hemisphere, which included Europe. These limits were not initially, but then were later extended to the Americas, which had not previously been subjected to numerical restrictions, though Mexicans throughout the 20th century were still subject to deportation. And thus, between 1968 and 1980, the number of visas available to Mexicans dropped from a virtually unlimited supply to 20,000 per year. As sociologist Doug Massey has explained, coupled with demographic and economic factors, these changes in the law meant that only one outcome was possible: an explosion of illegal immigration. In achieving formal equality, the 1965 reforms created a kind of disparate impact. Because of the law's ostensibly equality-enhancing numerical limits, much of the migration that had occurred freely as a function of the shared border and interconnected lives of US and Mexico became illegal. As of 2021, the unauthorized population sits at approximately 10.5 million, 22% of the population of the foreign-born and 3% of the overall population. The rise and persistence of illegal immigration throughout the 1920s and early 2000s, much like the unprecedented pressure on today's border that no longer comes from Mexicans, but rather from Venezuelans and others fleeing state collapse, was likely exacerbated by deliberate policy choices in the United States and elsewhere that reflect the influence of so-called neoliberalism and the business lobby, but also the civil rights consensus that consistently demands fetters on the government and its enforcement on the limits of entry. In other words, even if we can't tease out precisely how, the United States in some general sense is author and participant in the migration dynamics that continually give rise to the claims on the nation's attention. As I've noted, proponents of the self-government paradigm recognize that conceptions of justice or the nation's stated commitments to certain principles might require some relaxation of the border. Typically, they acknowledge a well-functioning society's obligation to provide protection to the proverbial refugees whose nation of origin either actively persecutes or cannot stop others from persecuting them. Even Walzer, in his defense of closure, recognizes the principles of mutual aid, which stops well short of establishing a right to entry or justifying open borders, and is defined by hospitality, assistance, and goodwill. But the very particularly defined idea of the refugee developed in the aftermath of World War II can scarcely account for or contain the multitude of reasons that drive migration and are bringing the problems of the world to the United States and other wealthy countries in human form. More pointedly, the civil rights paradigm generates no ex-ante account of how to manage these cross-border interdependencies, only ex-post ameliorations with devastating consequences for our internal democratic dialogue. So how might we put all of this together? Each of the paradigms I've tried to define shapes political discourse over immigration and has marked the immigration code and immigration jurisprudence in ways that have contributed to what we might call extreme values confusion. The self-government paradigm fits comfortably within the larger project of radically reducing income inequality by challenging the very foundation of the neoliberal order and rethinking immigrant admissions, if not enforcement, in service of these goals. The nativistic version of the self-government paradigm has clearly captured the Republican Party and fueled right-wing figures around the globe, which in turn, for the moment, has pulled much of the establishment of the Democratic Party in a restrictionist direction, albeit without the increasingly grotesque nativism and calls for mass roundups inside the United States, if only in service of an election imperative. The second civil rights paradigm retains some political purchase in the claims of DACA recipients and would-be dreamers, though repeated political failures to change their legal status once and for all contributes to a sense of resigned deflation on this front. The political window on legalization more generally may have closed, and we shall see if the renewed federalist ferment over how to manage record pressures on the southern border because of a series of migration-producing crises abroad leads to lasting retrenchment by even blue states and cities on the rights of migrants. Even more important, the Roberts Court's immigration jurisprudence is increasingly coming to look like a radical break with the jurisprudential order that underpinned the imperfect civil rights paradigm forged in the 20th century. These developments merit a lecture in themselves, but I point here to two cases that represent startling ruptures with the rights-based past. In Trump versus Hawaii, the court appears to have done what some of us previously thought unthinkable, perhaps naively so, to hold that an immigration policy, even if we know it to have been motivated by blatant official animus against a religion, must be upheld so long as the government proffers some rational national security basis for it. Not only does Chief Justice Roberts' opinion apply a highly deferential standard of review that requires the government to provide only a facially legitimate and bona fide reason for its actions, it purports to apply a heightened version of rational basis review for the sake of argument and concludes that even an established discriminatory motive would not have warranted invalidation of the government's actions, as long as another facially legitimate reason for the exclusion existed. Instead of attempting to contextualize, diminish, or otherwise cabin the anti-Muslim statements of the president, which Justice Sotomayor powerfully recounted in dissent, Roberts concludes that those statements and the motivations they arguably reflect are beside the point. For the first time, the court upheld an action by the political branches that could reasonably have been characterized as a violation of ordinary domestic constitutional law. In this case, government action predicated on grounds ordinarily considered illicit. And in DHS versus Throssingum, a technically very complicated case, Justice Alito's opinion for the court effectively announced the court's intention to retreat from constitutional review of congressional schemes to enforce the immigration laws. And in part of the opinion unnecessary to the resolution of the case, Alito disclaims that the due process clause applied to Throssingum simply because he set foot into U.S. territory. He remained on the threshold, which meant that he had only those rights Congress saw fit to give him. Though Alito does not explain whether and how far this reasoning extends beyond an individual like Throssingum who had just entered the country, the stunning implications of his reasoning become apparent when he underscores that being stopped at the border is in fact a term of art, and that someone paroled elsewhere in the country for years pending removal would appear also to be at the threshold. Not only does this reference suggest that Congress's authorization of expedited removal for any non-citizen who has not been admitted and has been in the United States for fewer than 2 years is perfectly constitutional, an authorization no executive until the Trump administration had sought to utilize for fear of its unconstitutionality, it suggests that Congress may go still further. Finally, the global network paradigm may be at least in accord with our present political and legal moment, but it is actually central to the policymaking that persists, regardless of what pundits, lawmakers, and political operatives clamor on about. Its reality, if not its moral claims, underscore that it is imperative that we hold two concepts in our head at once, and this is where I attempt to achieve resolution. We must understand first that the United States is a nation situated in a set of transnational networks, where us-them or friend-enemy dichotomies are inapposite as applied to the tactile human phenomenon of migration that the United States has never been without. And that second, at the same time, in that context, we must figure out how to sustain a flourishing democratic nation and a sense of peoplehood. The acceptance of American embeddedness and even responsibility demands pragmatism, which necessitates creative use of discretionary tools to manage people who exist in actual physical space. The effective use of these tools over time requires officials to be honest about the fact that not even a sovereign nation can close its borders as if they were operated by an on-off switch. Our embeddedness also demands clear-eyed acceptance of the real limits of externalizing solutions, which are so popular, even as it could remain worthwhile to pursue them. This means accepting the dysfunctions that illegal immigration produces within society and political culture. to name a few: heightening intergroup resentment, producing labor exploitation, creating whole communities under constant threat of surveillance and enforcement, and doing something about it ex ante. Instead of relying on ex post legalizations that our political culture now seems incapable of producing, in part because of the refusal to reckon with the embeddedness that produced it. The commitment to a flourishing nation in this context, which we, I think, must accept, requires establishing control, and this is the other piece of the puzzle, or at least the picture of control. A difficult prospect when the media and the Republican Party and its immigration entrepreneurs depend on pictures of chaos. Indeed, some social science research supports the proposition that an increased sense of control over borders can soften anti-immigrant sentiment. A softening, I would argue, is essential to producing a constructive immigration policy. This need to establish control, in turn, necessitates tolerance of resources for enforcement, which may include tolerance for quicker decision-making in immigration cases at the border and in the interior. The democratic aim also demands a radical commitment to incorporation, which means strategies that address the distrust that diversity and cultural change can produce, as well as the emergence of segmented assimilation models whereby newly arrived immigrants incorporate into the highly stratified social structure of US society by race and class. Precisely how to foster this social trust, defined as expectations of others' reliability and benevolence, in context of high immigration, has emerged in recent years as a core focus in social science. This work can be difficult, but centrally involves identifying and nurturing shared norms between immigrants and the host society, even as cultural markers remain distinct. Making a version of democratic embeddedness viable also requires recurring political justification of immigration and immigrant incorporation. Claims that our acceptance of these phenomena must flow from our civil rights commitments will be insufficient. The claims cannot be justified by prior commitments to equality and incorporation enshrined in the 14th Amendment. But the historically drawn connection between the immigrant-seeking condition and the protagonists of the civil rights movement can do important work. In his account of what finally prompted Congress to enact and President Reagan to sign the legalization program of 1986, Peter Schuck contends that the standard pluralist model of the legislative process cannot explain the dramatic and expansionist policy adopted then, or a few years later in 1990. He instead cites the power of ideas and values that can, quote, precede interests as well as advance them, contending that popular assumptions about the benefits of ethnic diversity and family unification and the belief that human rights, civil liberties, and due process norms should govern our treatment of even illegal immigrants help to galvanize a consensus around an expansive immigration policy. Rhetorically linking immigrant incorporation to the paradigmatic social struggle for inclusion, the civil rights movement, could thus provide some of the historical and emotional resources necessary to break through the public ambivalence that hangs over discussions of incorporation. Indeed, the claim that public policy should strive to avoid the creation and perpetuation of castes seems appropriate in light of the reconciliation between democratic flourishing and global embeddedness I suggest is required. In the end, we might describe this attempted resolution as an appeal to a concept of mutual benefit, predicated on an analysis of incorporation that takes into account the non-citizens and the polity's interests both, reframing the former as advantageous to the latter, including because doing so coheres with the polity's principle and commitments. In this way, grand ideas like sovereignty, justice, and equality become part of the pragmatic struggle that acknowledges the complexity of the polity, how it takes shape over time, and what is required to keep it together. Thank you very much for listening.
Questions, comments?
Hi, my name is Guy-Uriel here. My question may be a little bit more kind of on the political side of your talk, but you mentioned the shift of kind of the bipartisan nature of immigration, both for and against, in the early 2000s to more of a partisan vibe. And I'm kind of curious, what are your thoughts on where the sort of conservative libertarian side of the immigration argument in the early 2000s has gone today? Does it have a home? And if it doesn't, where do you think its home is going to be going forward?
It still exists. It exists in the form of people making arguments for radical freedom and reducing barriers to entry, and it sits alongside defenses of free trade and the like. Most lawmakers who advocate that point of view have retired from the Republican Party, and so they've left. Those people have left the building. Some of them have died. Some of them are playing golf. So, and I think they were for other reasons they were pushed out because of the way that the sorting has occurred over the last several years. Whether they've come into a kind of a centrist fold that might help shape policy, I don't know, and I'm skeptical that that's the case, because I think that there's not a lot of political room for those sorts of arguments at the moment.
So fascinating, thank you so much. I know very little about this topic. Most of what I know, I will now know as a result of having listened to this lecture. But one of the things that's very striking to me, you made a fair amount of it, is that what you're talking about here is a global problem. I mean, there are people all over the globe who want to migrate because they're in bad circumstances, and it's mostly the global north that wants to exclude the migration, but the phenomenon is by no means limited to the United States. It's being felt throughout the world. And so everything that you say by way of synthesis and happy resolution, a platform, a program for going forward, sounds right, but it also sounds very vague. And it makes me wonder, can you point to some place in the world that is doing markedly better than we are, and say a little bit about what we might or might not be able to learn from such a place, if there is one, and if there isn't, what that has to say about the situation we're in.
Yeah, I think Canada is doing markedly better than the United States. It's a differently situated country. It has not experienced the high levels of illegal immigration, and for obvious reasons, that its border is with us and not with a much less developed country. But it has a larger percentage of foreign-born population per capita than the United States does. And so it's not as if there haven't been the challenges associated with cultural threat and the demands of integrating new people into the society. I think the difference between Canada and the United States is that Canada has an aggressive incorporation policy that's funded by the state, supported by the state, and is committed to various forms of integration, both economic and cultural. And that material investment in incorporation, according to sociologists who've studied it, including several at Berkeley, makes a dramatic difference in things like rates of naturalization, perceptions by members of the receiving society, and the like. And that's part of what I mean by the radical commitment to an incorporation strategy, which has been resisted in the United States for a variety of reasons. Some of it includes just a different understanding of the role of the state generally in these dynamics, and a reliance on the market instead, and maybe more of a perception of immigration as an economic engine than something that's a more emotional form of nation building. But I think it's also born out of a concern about coercion. And even though Canada has a formal multiculturalism policy, the concern about imposing values, because it's resonant with Americanization programs of the progressive era, has made the processes of incorporation much more diffuse and much less centralized. So I think that there are many reasons why the United States can't look like Canada, but there are ways in which they have policy models that would be useful in the American setting. I think the harder example to point to, and this is one that's worth thinking about, is what some countries in Europe are doing in response to the sense of balkanization that is occurring. And there are people who point to a key distinction between the United States and Europe, which is that Europe has a much more robust welfare state. And so its native citizens are much more protective of that. We have built in a kind of libertarian approach that enables larger scale immigration, including larger scale illegal immigration, without a great deal of social unrest until relatively recently, or at least it's localized. But countries like Denmark, as a way of addressing this, have affirmative policies of breaking up ethnic concentration. of ensuring that parallel societies don't emerge. Again, this is why kind of the anti-coercion, anti-hierarchical understanding of culture and freedom in the United States might make that kind of a policy difficult to adopt, because it does have a feel of assimilation in the bad sense of the term. But those kinds of, whether those succeed, they're experiments in progress, whether they succeed in reducing anti-immigrant sentiment and enabling the kind of integration that they aspire to is worth tracking.
I think we have time for one more question from Professor Sharp.
Thank you, that was great. If I may pose my question in the most provocative way possible, I wonder if the civil rights paradigm isn't a bigger part of your target than you're admitting that it is, for a couple of reasons, one of which is it's concerned with a specific identitarian framework and reifying that as much as possible. And your answer to Fallon, I think, sort of underscores that as the target. But also that what the court is doing is essentially leaving things to sort of removing the constitutional barrier, but leaving things to the political process, which one might say, given sort of like the pragmatic discretion that one wants, or like you might want, to reframe and rebuild a different conception of identity, gives that freedom. So, but the barrier is the civil rights framework. So I wonder if it isn't a bigger target for you than you might be admit.
So you're suggesting that dismantling it might actually be important to the aspiration.
Your vision of the reconstruction.
Yeah, it's certainly possible. I would not say that is a reason to celebrate what the Roberts Court has done, because I do think that they're radically departing not just from the civil rights paradigm, but from a basic understanding of the rule of law and restraint on coercive government treatment of people in its custody. But this begins to get into questions about how much the court should be restraining the political process. And when it comes to the operation of the enforcement machinery, I think that it's critical that procedural protections survive, and that the anchor of due process is what prevents gross human rights abuses in the system from occurring, or occurring at a greater scale. But I do think that beyond that, I would resist court intervention, including in overseeing maybe what states and localities might want to experiment with, because they are the actual engine of immigrant incorporation as it has evolved over time. And I think that the claims that people make that this has to follow from civil rights principles from the 14th Amendment are not constructive in the political dialogue that's necessary, because it leads to a refusal to engage in trade-offs. And those trade-offs, if we don't engage in them, make the synthesis that I hope we can achieve impossible. And so in that sense, I would resist the kind of very moralistic understanding rooted in this historical example that has real connection to what people are fighting for on behalf of immigrant rights, precisely because it shuts down the trade-offs that are necessary.
Great, please join me in thanking